Robert Lee Vogel, Esquire, was representing a client in a criminal case when he realized a conflict of interest was present. He withdrew from the case and notified the defendant, without releasing the reason behind his withdrawal. The defendant demanded an explanation, and the judge also sided with the defendant. Mr. Vogel mailed a letter that included confidential information regarding the defendant. This letter was sent to both the defendant herself as well as the judge deciding the case. RPC 1.98 specifically states the former client must give written consent to release specific information. Some will say the letter she emailed to him is an acceptable form of written consent, which in some cases it can be. However, Mr. Vogel could have responded to the defendant and stated there was a conflict of interest and informed the defendant that he could give her a more detailed reason behind it, but cannot do so without her consent, as some of the information falls under client-attorney privilege. RPC 1.9b states again, informed consent in writing. I do not believe the defendant in this case gave the attorney consent to release any confidential information, and he could have spoken with her privately along with a letter stating the conflict of interest. He did not have to specify confidential information to the judge via the letter he wrote, but if she wanted a more detailed explanation, he could have spoken to her regarding the specifics. RPC 1.9 reiterates the two previous points and adds, or the information becomes generally known. One could argue that in order to give his explanation for Mr. Vogel's release of confidential information, he would have had to state specific facts about the case, thus those facts becoming generally known. That being said, giving the judge this information automatically puts the judge in a similar predicament that Mr. Vogel found himself in. Conflict of interest would have been enough to suffice the reasoning, and he would not have been punished. I agree with the court's findings that Mr. Vogel violated RPC 1.9A and B. Both state the client must give written consent. Although an email can be considered written consent in some cases, it is not applied to this particular case because the defendant did not specify what type of information could be given. She just wanted an explanation as to why he had to withdraw from her case. Mr. Vogel could have easily responded and stated there was simply a conflict of interest and left it at that, and then given the defendant the option, if she needed a more detailed explanation, he could speak with her privately, as the judge did not need to know this information before it went to trial. However, I do not believe he violated RPC 1.9c, even though it does also state written consent must be given. It also adds that the information must become generally known, which it was not. It was only known through Mr. Vogel's correspondence.